Well, let's move on to our other focus tonight. The convict who was 17 years old when a young college student was fatally gang raped in the Delhi bus in 2012 will not be tried by a regular court, says the Supreme Court today, rejecting the request of the victim's parents. The convict's trial was handled by a court for juveniles and was given a maximum sentence of 3 years at a reform home in September 2013. The parents of the woman who died says the man who was tried as a minor has been let off too easily.
आज फिर एक बार हमारा मन बहुत दुख सा गया, झिझोड़ सा गया कि इतना क्राइम करने वाला मुजरिम। हम तो इसीलिए पटिशन डाले थे कि शायद कुछ इस पे विचार किया जाएगा कि उसने क्या किया है, क्या नहीं किया है।
Disappointment for Nirbhaya's family as the Supreme Court dismissed a plea by the parents of the December 2012 gang rape victim to try the juvenile convict in a regular court and face trial as an adult. He was just 6 months short of his 18th birthday and was an equal participant in a brutal and fatal crime. The court said it could not be tempted to enter the arena of the legislature and must confine itself with only legality. It further said there was no question of sending juveniles to regular courts and that the legislature had determined the age of the juvenile as per international conventions. The Justice Verma panel had retained the age of an adult at 18, citing the Convention of Rights of Children for not allowing capital punishment or life sentence for those below 18 years.
Will it in any way diminish violence against women? No. These are perverse agendas that we have started following. There is no shortcut to providing a secure and dignified existence to women. The shortcut is not death penalty, and the shortcut is not putting juveniles into the adult prison system.
However, many countries like the US and UK, the jurisdiction of juvenile courts is often waived when a juvenile commits a serious crime and the case is transferred to an adult court.
Internationally, you look at the US laws. US laws are very different. They recognize 14, 16, and that act will not apply because the person's committed the crime. So they are pushed under a stricter and firmer punishment. In India, we let go of many wrongs, and this is one of them.
According to the data assessed by the Ministry of Home Affairs, the crimes committed by juveniles are on the rise. In 2010, 858 rape cases involved juveniles. This rose to 1,149 in 2011, and in 2012, the year Nirbhaya met with her brutal fate, it was 1,175 cases reported. In August 2013, the juvenile was found guilty on charges of rape and murder but sent to reform facility for only 3 years, the maximum punishment for a juvenile. For the parents, it's just a figure. The hard reality remains that crimes committed by juveniles are on the rise. So should India now take on practices like the US and the UK where the gravity of the crime and not the age of the accused determines the sentence? Or is the lowering of the age of the juvenile really a long-term solution? The Bureau inputs in New Delhi, Bhairavi Singh for NDTV.
Right, well, whether this is really the end of the road for the young girl's parents now, we will discuss that on the show tonight as well. Joining me in the studio, Subramanian Swamy, the petitioner for lowering the age of juvenile convicts in the Supreme Court. We're also being joined in the studio by B.K. Gupta, the former Delhi Police Commissioner, and Vrinda Grover, also a senior Supreme Court lawyer. From Mumbai, Flavia Agnes joins us, the women's rights activist. First to you, Mr. Swamy, you were the petitioner in this case. The Supreme Court has very clearly said this is the end of the road. So what next?
Well, the Supreme Court said that they would not be able to go beyond what they saw as the intention of Parliament, which was to regard a flat cut-off point of 18 years. I didn't ask for 18 years to be reduced. What I said is that it should provide for an exception, where the juvenile crime is not of the nature of stealing a pastry in a bakery shop or stealing a bicycle, but which involves depriving somebody else of their dignity or their life, as in the case of rape and murder. And many countries have this provision. For instance, the United States has what is called as a waiver. A juvenile court can determine whether the crime is so extensive, so horrendous or so heinous that they would give a waiver to say that this particular person should be tried in a normal court. That's what I was arguing, but the court didn't feel that they had the power to do it. They felt that there was no unconstitutionality or illegality or inconsistency, and therefore they have to stick to what the parliament has passed. The end of the road is really parliament. So there will be a new parliament in 2 months from now. That's when we might bring in a new law.
Looking at the law again. Okay, well, that's, I guess, the only way forward right now. Mr. Gupta and Vrinda Grover, also I want to ask you, Mr. Gupta, actually, with this juvenile justice system, the way it operates, one of the questions that was raised at this point in time is that, as we've heard, that a case should be tried also according to the gravity of the crime committed. Now, this boy, many talked about the fact that he was 6 months short of his 18th birthday. These are young men who knew exactly what they were doing at the time. As a law enforcement body, how difficult is it for the police to deal with the legal system on these cases?
I perfectly agree with Mr. Swami that until and unless there is an amendment to the Juvenile Justice Act, nothing much can be done, because it has got to be implemented in letter and spirit, and there is a very strict provision. Even if a police officer detains a juvenile against the spirit of this particular law, there is a provision of penalty against him. Now, so that is the situation right now. But on the ground, the reality is this, that now suppose there were 3 juveniles involved in this particular case, they would have all been let off with just 3 years punishment, maximum punishment. Now, Delhi police, they have also put up a case before the government that there should be, in the event of a graver crime, there should be enhanced punishment.
Okay.
Provision of enhanced punishment, like in many other countries, in USA or UK.
Right. So, the Supreme Court clearly in its wisdom has decided that there is no question of looking at the gravity of the crime, but they are going to follow the law to the letter in this particular case. No scope for interpretation. Vrinda Grover, why is it so unreasonable to actually suggest that there should be an exception included in the law depending on the kind of crime that has been committed?
I think there are 2 things we should at least today now place on the table. These arguments and much more was put to the Supreme Court.
Right.
Now, let us see how the Supreme Court has dealt with each and every one of these arguments, and what does the Supreme Court say. I was appearing in this case very importantly for child rights groups, for women's rights groups, for persons who have been chairperson of the National Commission for Protection of Child Rights.
Right.
These are people who have experience on the ground of victims and juveniles, and they have worked with the law. So, that is the experience and insight that we brought to the court. The court looked at all these arguments, and the court said, and also looked at these other jurisdictions of US, UK that are repeatedly being cited. And the court said that the purpose and the objective of the Juvenile Justice Act is reformation and rehabilitation. This is not based on some weak-kneed, bleeding heart analysis. This is what the UN Convention on the Rights of the Child says, to which India is a party. When we ratify a convention, we also accept the international obligation. What does that say? Make 18 years the age. The USA of A actually does not ratify any human rights convention. So, to cite US as an example of a human rights jurisprudence is totally flawed.
Okay.
The court has looked at all those. In fact, the court has looked at many more jurisdictions and said we have to do as a sovereign nation what we need to do.
Okay.
On the issue, just a moment. On the issue of why is this done?
Right.
They've also looked at neuroscience.
Okay.
Where US is now changing its opinion and
Okay.
saying
So
the psychosocial maturity is not there. Therefore, give a reformative approach.
We'll come back to you, Mr. Swami, in just a second. Let's just get Flavia Agnes in on this for a moment. Ms. Agnes, you've been waiting in Mumbai and listening to the debate. The point Vrinda Grover is making is that the Supreme Court also talked about reform and rehabilitation of these convicts. In your experience in the rights arena, do you see reform and rehabilitation when people have been convicted of such violent crimes?
Yes, the reform and rehabilitation must be integral part of our justice system. It is not outside of the justice system at all. Unfortunately, today it doesn't exist. If you see the homes in which the juveniles are placed, they are in such pathetic condition. There's no counseling, there's no any skill training, any move to put this child back into the society as an adult, and that is where we are lacking. We are not lacking by not reducing the age, but we are lacking by not providing a viable program for the child.
Okay.
Once a child is there for 3 years or 6 years, whatever, there is no program at all for these children.
Well, Mr.
And that
Swami,
is the sad, pathetic part of it.
You are the petitioner. Now, this is the argument that ostensibly works for the juvenile justice system, that at the end of the day, you're talking about young minds, there's a scope to rehabilitate them, and that's why this act should not be tampered with, and the implementation should not be tampered on the one hand. On the other hand, there's an admission by the very people who are saying the act should not be tampered with, that the system of reform and rehabilitation is not in place. So it's catch-22.
Well, in addition to that, first of all, let me say that there are countries which have signed the UN conventions,
right,
but with reservations, unlike India, which was unconditional. And what the UN convention said and what the Beijing rules said, I won't go into the details of it. They also had recognized that there is something called heinous crimes, but in case of England, for example, they have they expressed their reservation on this blanket age thing. So they have a lower age, 14, the age of 14 in England. Now the real question is, if you take this law in this bland form, you may get into absurd situations. Supposing Pakistan trains an Indian mujahideen to become a terrorist at the age of 17 years and 11 months, and then he picks an AK-47 and shoots 20 people to their death. Are we going to treat him as a juvenile and let him off in 3 years? That's a question, because somebody else is losing his life. So there is an the victims have a right to.
All right, Vrinda Grover, I heard you say not at all. When,
I don't think it's a catch-22 situation at all. I think now where the debate needs to move is where will the emphasis be of the debate. Let us put our scrutiny and energy on the system and ask the state, put in place the provision for counseling, put in place the care plans, make the juvenile homes spaces of reform and rehabilitation. That is where the debate should be. Why are those not under scrutiny? Unfortunately, we've all become, as a society, instead of seeking long-term measures of becoming a humane, civilized society, we are only lusting for blood, and that is not going to resolve the problem. Let us ask the state, why are these juvenile homes not functioning? What is the plans you have put in place for the juveniles to recuperate? What are the counseling sessions that are being done? Why are we not asking these pertinent issues?
But Ms. Grover, if I may ask, when counsellors go in and work with some of these convicts in juvenile homes, isn't there also sometimes, while there might be a 50% chance of rehabilitation for some of them, isn't there also often an understanding that some people are just sociopaths or psychopaths, violent by nature, irrespective of their age? And how do you deal with those people then?
I think, I'm not a qualified psychologist, but in the course of this petition, I did meet various child rights groups and discuss this. I think there are two things here. A lot of the juveniles that we are seeing were committing crime. And one of the slides that you showed, I think, is a little misleading. There is a general rise in crime also. If you want to show the rise in juvenile crime, we will have to get the percentile for it. Only then we'll be able to make a proper assessment.
Okay.
Secondly, a lot of these juveniles are actually children in need of care and protection, where the state has totally failed. These children are living as destitutes, as vagrants on the street, getting into crime. Where is the responsibility of society and state going to commence? Why do we start at the end of the story and not compel the state to start at the beginning of the story? That is when we will not have to discuss whether somebody is a psychopath or a sociopath, because you will provide conditions where the person can actually grow into a better human being.
Right. Mr. Gupta, do you agree with that?
No, I agree with the lady that you see, right now there is hardly any system existing for reformation and rehabilitation of a juvenile. If you visit a juvenile home, it is an absolutely pathetic condition. And there has been number of escapes from juvenile homes. Rather, they are becoming more hardened people when they come out of the homes. So, there are a lot of malpractices existing there.
So, Mr. Swami, don't you think that that's something the state should also look at, the fact that you're not providing this kind of service?
Yeah, but that still doesn't go away from the main fundamental question. Yes, the reformation system should be more updated, should be more modern, should have good psychologists, psychiatrists, etc. But the fact is that at the age of 17 years and little more than 17 and below 18, it's possible for somebody to be a hardened criminal, whatever it is. I have myself, I had talked to a lot of doctors in this while preparing for this case. They say, yes, there are some people like that. Now, you've got to have an exception to the law. This blanket concept of 18 years full stop, I think it's an absolutely inane concept. It is totally inconsistent with the variations that you see in human behavior.
And Flavia Agnes, we'll ask you this question as well. There are two views over here. One is that there is scope for improvement, there is scope for reform, and the other is that you, at 17 and a half as opposed to 18, you're pretty conscious and clear of what you're doing. You know what's right, you know what's wrong. Why should you not be held accountable for knowing it just because you are 6 months below the age of being an adult?
My question is to the speaker before me, at what age do you become a psychopath or sociopath? Do you become at 17? Do you become at 16? Do you become at 15? Do you become at 14? Tomorrow you have a child committing a crime at the age of 15. Then again we will say the age should be reduced to 14. Supposing there is a child at 14 committing a crime, are we going to say at the age of 12 the child should be labelled as a psychopath and hanged to death? Are we saying that? Are we for hanging criminals? Because in the Delhi gang rape, the rest of them got death penalty. So do we want this child also to be hanged? In Mumbai, for both the cases, there is a boy of 19 who's facing, who might be given death penalty today. So what are we saying? Hang all these poor boys who commit crimes, but at the same time, for the richer people, we have a different set of laws. We have different kinds of lawyering over there. We have different kind of arguments over there. And for the poor, there was an informant boy who was only 12 in the Mumbai Shakti Mills case. Tomorrow he might have also committed the crime because he is with his friends. Are we then saying that he also committed the crime? So the age should be reduced at 12. At what point do we stop?
Okay.
18 is the benchmark that we have followed, and I think what we need to look at is between 10 and 18, what happens to our boys? What kind of societies are they being brought up? Are they born psychopaths? Are they born criminal? Or there's something happens?
Okay, between 10 and 18 is a large gap in an adolescent's growth. What happens to a boy? But what happens to a boy between 17 and a half and 18? Brinda Grover, okay, you take that.
We need to see the latest developments in neuroscience is telling us is that the frontal cortex of the brain, and the Supreme Court looks at that data. The US Supreme Court has relied on that, and this is a new breaking of science that we are seeing. What does it say? That there can be cognitive maturity, but is there psychosocial maturity? And they say 16 to 18 is actually the most volatile period psychologically. You are most under peer pressure. You may find it difficult to resist taking rash actions. You're not able to make good judgment. Therefore, to punish a person who commits a crime, grave or heinous as it may be, is actually counterproductive because the culpability does not exist. Therefore, reformation is advised. Right. And it is, just to make a clarification, the system doesn't say he is not accountable. The system has a different approach to the person.
To the accountability,
First of all, you see, the thing is that where you draw the line is in the nature of the crime committed. That's the way. I'm saying we'll keep it 18, but when the nature of the crime is of such, there you have to make an exception. Secondly, let me say there are other acts, you see, where a child is defined. For example, in child labor, it is 14.
Right.
In the age of consent, for
marriage
just proposed at
different.
16.
Yeah.
So it's a very insensitive thing to say that for whatever crime is being committed, it should be 18, including that for terrorism.
There are interesting contradictions, of course, as you're pointing out as well. But nonetheless, if that is the law, we are upholding the law in letter and spirit. And we're talking about reformation at the end of the day. So let's hope that there is going to be some learning from this. As Subramanian Swami says, there will be a new government come June. So who knows if this law will...
Let's hope they are for a humane society.
Exactly.
That's a
humane
definitional
society.
problem.
Well, absolutely. But we have absolutely no more time left on the show tonight, so we'll have to leave it at that. Thank you all very much for joining us on the Buck Stops here tonight.